Okay, guys, it is chapter 12. We're finally here. It's the home stretch. Hopefully the weather is much nicer when we watch this video than when I'm filming it. Here's hoping, but in Edmonton, it's probably not. So chapter 12 talks about damages. Now, a lot of people enter into lawsuits thinking that they're doing it for the principle of the matter, and they think that until they get their first legal bill. And then they realize that they should probably figure out what exactly they're going to be able to get as monetary compensation for a breach of contract. Chapter 12 talks about remedies, and those remedies are most often some form of contractual damages, so payment. I'm going to talk in this video a little bit about expectation damages, reliance damages, and how those are calculated, and then talk a little bit about mitigation. Now, there are a lot more remedies, many more remedies discussed in the textbook. However, they're pretty self-explanatory and straightforward. I just want to focus on how these damages are calculated. So let's take a look. The default calculation of damages in a breach of contract litigation is expectation damages. Put me where I expect it to be had you not broke your promise. Okay, they're forward looking. This is opposite of torts, right? Torts are backwards looking. Put me where I was before. Now, expectation damages are calculated by figuring out the benefits of the contract. What did I expect to benefit from the contract? And what did I expect to, what sort of cost did I expect to incur? So if I expected at the end of the day to have in my possession a $1,000 iPhone, and I expected the cost was going to be $750 because I got a really good deal, my expectation damages are going to be $250. The benefit, I would expect to hold a $1,000 cell phone, minus the cost, I would expect to pay $750. That is expectation damages. Now, expectation damages are not going to amount to anything if the contract is for market value. So if I enter into a contract with Apple to spend $1,000 on a phone that has a market value of $1,000, there are no expectation damages. The benefit is $1,000. Subtract the cost, which is $1,000, and I'm left with zero. There are no damages, no expectation damages. I may still be entitled to what's called reliance damages. And so when we're looking at situations where expectation damages fall short, we have to look at whether or not a party is entitled to reliance damages. And what reliance damages do is they actually do look backwards, and they say, give me back what I expended. Give me back the money that I have spent, the costs that I've incurred in anticipation of your promise. So if we enter into a contract and I have to do a whole bunch of stuff and incur a whole bunch of costs before you fulfill your promise and you don't fulfill your promise, I may be able to sue for reliance damages and say, hey, it cost me $5,000 to get everything ready for you to perform your piano recital, and you never did. So give me the $5,000 that I've expended in reliance on your promise. So let's take a look at these in action. So because of the formula for expectation damages being benefits minus costs, market value of whatever is being purchased is very important because it's key to figuring out what exactly is the benefit and what exactly is the cost. So let's look at an example where the value of the commodity that's being purchased is variable, where it changes. So Rohan agrees to purchase Jill's house for $100,000. Then he puts down a $10,000 deposit. In breach of the agreement, Jill refuses to transfer the home. If the house is worth $100,000, there are no expectation damages. Where did Rohan expect to be? Well, he expected to be the owner of a $100,000 house, and he expected to pay $100,000 for that house. He expected to be net zero. There are no expectation damages. Let's look at scenario 2 though, which is a situation where the house has actually increased in value. So if the house is now worth $125,000, Rohan is going to be entitled to $35,000. Now, how did I get there? What we really need to conceptualize is, where is Rohan now? So Jill has breached the contract. Where is Rohan? Rohan is actually negative $10,000, right? He's given out $10,000 and has nothing in return. So he's negative $10,000. Where did he expect to be after the purchase of the home? Well, he expected to be up $25,000. He expected to have an asset that was worth $25,000 more than what he was going to pay. So where he wanted to be is up $25,000. Where he is minus $10,000. And so there's a $35,000 gap there. And therefore, those are the damages. So the damages is the difference in between where he expected to be and where he is. And it's larger because he's actually given out $10,000. Let's look at a third scenario, and that's when the house is worth $90,000. Now remember, expectation damages, the benefit under the contract minus the cost is going to be the expectation damages. The benefits here actually are less than the cost that Rohan would incur. So that number is in the negative. So he's not entitled to expectation damages at all. However, it doesn't really seem fair that he would have expended $10,000. He would have paid $10,000 to Jill, but have received nothing in return. So the question becomes, can he get reliance damages? And I want to compare this example with the first example that I gave you. The first example I gave you, the market value of the home was $100,000. So there were no expectation damages because it was a market value transaction. But Rohan would be entitled to claim reliance damages in the amount of $10,000 because the contract was for market value. It's different though in this circumstance, in circumstance number 3, and that's because he has entered into a losing contract. He has entered into a contract that is unprofitable. And the trick with reliance damages is that the court's not going to award reliance damages. The court will only award reliance damages to the extent that the contract was not unprofitable. So if at the end of the day, Rohan expected to lose $10,000, so had Jill performed her end of the bargain, Rohan was going to have an asset that was worth $10,000 less than what he paid for it. He's not going to be entitled to reliance damages for the $10,000 deposit because he was going to lose that money anyway. The court says, hey, you're going to lose that money anyway. So no, you're not entitled to reliance damages. So I hope that you're sitting there thinking, well, that doesn't really seem fair. So Rohan isn't entitled to expectation damages. He's not entitled to reliance damages. So what does that mean? Does Jill just get to pocket the $10,000 and breach the contract and walk away? And the answer is no. You'll recall from chapter 11 that Rohan, as the innocent party, is entitled to discharge the contract for breach, meaning that the contract no longer exists. And there is a type of damage award available, or a claim in what's called unjust enrichment. The textbook talks about it a little bit, and there are specific requirements. There must be a detriment, a corresponding benefit, and the most important part, there must be no juristic reason, no legal reason why someone has something that the other party doesn't. And so in this case, how does that apply? Well, because the contract is discharged, there is no longer a legal reason why Jill is walking around with $10,000 of Rohan's in her pocket. And so the court will award Rohan $10,000 in as a result of his claim in unjust enrichment. And the action for unjust enrichment is basically this. It's not really damages. It is you have something that is mine. There is no legal reason why you have it. Give it back. And so Rohan would be able to get his $10,000 back through that action. The last and final topic I want to talk about is this concept of a duty to mitigate. So when an innocent party has been wronged, there's been a breach of contract, the law says that they are obligated to staunch the bleeding. They're obligated to mitigate their losses. They are required to take reasonable steps to mitigate their loss, limit their losses. Now, that doesn't actually mean that they have to positively take the steps. What that does mean is that if they don't act reasonably, so if they just sit back and watch the losses continue to accrue, then what the court will do is they will actually limit the damages to the damages that would be suffered had they taken reasonable steps to stop the loss. Let's look at an example. ABC Corp leases commercial space in downtown Edmonton for 5 years at $50,000 a year. 1 year into the term, they have abandoned the lease. So the question is, as a landlord, what would you do? So ABC is on the hook for the whole 5 years. They're on the hook for $250,000. As a landlord, and you've been paid, and the landlord has been paid $50,000. So the landlord could just sit back for 4 years and not take any steps to lease that premises and try to sue for $200,000. There's no obligation for them to positively act to fix this. ABC agreed to lease this space for 5 years. However, if the landlord doesn't take reasonable steps, it is possible that ABC could go to court and say, look, here's the market in Edmonton. Here's all the evidence that I have that says had the landlord acted reasonably, they would have been able to lease this premises within 12 months. And had they done so, they would have only suffered $50,000 in damages. And therefore, that's all I should have to pay. That's all ABC Corp should have to pay. And if a judge, based on the evidence, is persuaded by this, even if the landlord did nothing and actually suffered the full $200,000 in damages, the court's only going to award the $50,000 because they're just going to take into account that they should have acted reasonably.